Once you set up your LLC, you have to make sure that you operate it appropriately so that the LLC will be responsible for debts and obligations of the company and not the individual owners. So there are a few things you want to make sure you do. One, set up a bank account and make sure that you don't commingle the individual personal funds of the owners with the bank account's funds. Also, you don't want to mix up the LLC property with the personal property of the individuals who own the LLC. Third, you want to make sure that any LLC transactions are clearly separated from personal transactions of the individual owners. One way to make sure that this is accomplished is when you're signing any document, you sign in an authorized capacity on behalf of the LLC and not in your individual capacity. For example, if you are a manager of the LLC, you would sign your name and then put manager of the LLC to make it clear that you're signing in that authorized representative capacity. You want to make sure you document all of the transactions between you and the company. For example, if you're contributing extra funds into the limited liability company, make sure that you sign a resolution or a document that says that you are contributing extra money into the company. You want to make sure that you follow the terms of the operating agreement. The operating agreement is a long, dense document, and you might be tempted to just put it aside and forget that you ever put it together. But you want to make sure that before you take any action, that you are operating consistent with the terms of the operating agreement, and it's clear that you're taking the terms seriously. As I discussed before about a manager of the LLC and the fiduciary duties or the heightened responsibility that a manager has to act in the best interest of the LLC, you have to remember that you can't act in a way that compromises the well-being of the company. And you can't try to take an opportunity that may benefit you individually, if you're a manager, that may hurt the limited liability company. Finally, you want to make sure that members have certain things that they have to vote on and managers have certain things that they have to vote on if you have a manager-managed LLC. Remember that members make all of the major decisions on behalf of the company. For example, if the articles of organization need to be amended, or if there's going to be a merger of the company, only members can make those decisions. Managers typically make day-to-day decisions on behalf of the company, such as hiring people, acquiring insurance, and entering into certain types of contracts. So remember that you have to be sure that you're aware of the decisions members make as opposed to managers, and follow your operating agreement, and then document those decisions in writing accordingly. Even if a company forms a limited liability company, it is able to convert that LLC to a corporation if it decides, for example, that it wants to receive financing from venture capitalists. It can make that switch. In order to convert an LLC to a C corporation, documents need to be filed with the state of Michigan as well as with the state of Delaware. In addition to the documents that are required to be filed, there are a number of filing fees that have to be paid with the state of Michigan and with the state of Delaware. And if you're doing this conversion, you really need to make sure you have legal counsel to help with that. And that will probably cost several $1,000s. So just keep that in mind when you're setting up the company and trying to decide if the LLC is best for you, that you can do the conversion, but it'll cost you.